Welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Today, we are going to discuss important issues appearing in the New Delhi edition of the Hindu newspaper dated 9th August 2018. Let's begin. The first news appears on page number 7. The news reads, Supreme Court constitutes a panel to look into issues plaguing jails in the country. And in this, the court resents Attorney General's remark on funding curbs. So, this particular news is with respect to the issue plaguing jails across the country. So, while deliberating upon the issues which are plaguing jails in the country, like overcrowding of prisons, conditions of under trials languishing in jails, and providing better facilities to these under trials who are languishing in jails, the central government, while deliberating upon these various issues, argued that while delivering judgment on various issues, the Supreme Court must consider budgetary restrictions of the government, as implementation of Supreme Court order puts a financial strain on the budgetary resources of the government. And this financial strain also has a spillover impact on other sectors of the government. So the government was effectively arguing on the budgetary constraints with respect to better conditioning of the under trial prisoners. In this instance, the court replied that in the present case that it was more concerned with the issues at hand in this present case, that is overcrowding of prisons as well as conditions of under trials. And in this respect, the court cannot abandon its duty to protect citizens' fundamental right to life and dignity. And on this, the court further warned the government that both the court and the government are on the same side as far as protection of fundamental rights of citizens are concerned. On the issue of allocation of resources, the Supreme Court advised the government to use the existing financial resources wisely. And while allocating resources, the government must consider the fulfillment of basic human rights of individuals. And while giving the order, the Supreme Court further ordered to set up a committee to be headed by a retired Supreme Court judge, who shall be assisted by 2 or 3 officers. And the mandate of the committee shall be to look into the present prison conditions across the country. So in the backdrop of this particular judgment, let us also go through certain steps recently taken by the government on prison reforms. In this respect, it's important to know that the Ministry of Home Affairs has recently approved this new prison manual 2016, which primarily aims at uniformity of all the laws, rules, regulations, etc. regarding governing the administration of prisons and management of prisoners across country. Further, it says that the new manual has given special attention to access to free legal services, which is provided under Article 39A of the Indian Constitution. This Article 39A was added by the Constitution 42nd Amendment. And a question in this respect has been asked by UPSC with respect to the directive principles, that which of the directive principles have been added in the Indian Constitution by 42nd Amendment. It further says that the manual gives special attention on access to free legal services, needs of women prisoners, rights of prisoners sentenced to death, modernization and computerization of prisons, provisions for children of women prisoners, inspection of prison, etc. And in this respect, this prison manual has also provided for certain guidelines. So let us go through that particular guideline. So the guideline includes under trial review committee to be set up in each district, earliest release of under trials as per the provision of the law, impaneling competent lawyers for the under trials, improvement in the living conditions of jails, especially for women, management information system to be placed in all jails for the records, as well as annual review of the implementation of Model Prison Manual 2016. However, it is yet to be seen how all these guidelines are implemented properly by the state authorities as well as the police officials. Thus, implementation of these guidelines becomes a challenge for the government authorities, especially the police officials. And it is in this respect that the state authorities must ensure implementation of such prison manuals as well as guidelines. So these guidelines becomes important not only to understand, but also the fact that these guidelines, if implemented, shall deliver basic human rights to these prisoners as well as under trials in the prison. So while discussing about under trials, let us go through an important case which actually set this entire concept of public interest litigation in the country. The case we are talking about is of Husainera Khatun versus State of Bihar. And this particular case becomes extremely important as this case is considered to be the first case of public interest litigation in India. In this particular case, senior advocate Kapila Hingorani wrote a letter to the Supreme Court and stated the various deplorable conditions of under trial prisoners. And in this letter, the advocate asked the Honorable Supreme Court to take suo motu action, that is, action by their own accord. This particular letter was accepted by Honorable Justice P.N. Bhagwati, and in the entire process of hearing this case, around 40,000 under trial prisoners were released from jails across the country. And this case started the revolution of so-called public interest litigation in the country. So this case specifically with respect to under trials on public interest litigation becomes very important to understand, and you can use this particular case while answer writing in any of the questions asked on police reforms. So in this news, the Supreme Court has constituted a panel to look into the conditions of prisons. So let's wait and watch what this particular panel has to report on the conditions and what are the suggestions which will be made by this panel in time to come. As far as the syllabus is concerned, this forms a part of JS paper 2, specifically under functions and responsibilities of union and the states, government policies and interventions for development in various sectors, including prison reforms and welfare schemes for the vulnerable sections of the population by both center as well as states, and including mechanisms and laws which can be made for betterment of these vulnerable sections. So this news on a panel constituted by the Supreme Court on looking into the conditions of overcrowding of prisons and conditions of under trial becomes extremely important, as it also affects their basic human rights, including their right to life as well as dignity. Now this particular question was asked in the prelims of 2017. The question read, which principle among the following was added to the directive principles of state policy by 42nd Amendment to the Indian Constitution? And there were 4 options provided in this particular answer, in which one of them were added by the Constitution 42nd Amendment. So in such type of question, it becomes important for us to know that which provisions were added in the Constitution with respect to Constitution 42nd Amendment, and specifically with respect to directive principles of state policy. Let's go through the option. Equal pay for equal work for both men and women, participation of workers in the management of industries, right to work, education and public assistance, securing living wage and human conditions of work to workers. So in order to answer this particular question, let's go through the various provisions added in the directive principles by the Constitution 42nd Amendment. As you can see, these 3 provisions were added in the directive principles by Constitution 42nd Amendment. And these provisions are Article 39A with respect to equal justice and free legal aid, Article 43A with respect to participation of workers in management of industries, and Article 48A with respect to protection and improvement of environment and safeguarding of forest and wildlife. So after knowing the different provisions which were added by the Constitution 42nd Amendment, let's again try to solve this particular answer. So you can see that option B here, which provides for participation of workers in the management of industries, and you can also see here the same provisions under Article 43A, which was added by 42nd Amendment. So in this particular question, B was the correct answer. So these directive principles which were added by different constitution amendments can be asked by UPSC in the prelims examination. As far as the mains are concerned, questions can be asked with respect to implementation of guidelines of police manuals as well as challenge faced by government authorities in terms of ensuring its implementation. Thus, this issue of the condition of under trial prisons, specifically in the backdrop of first PIL in the Husainera Khatun case, becomes extremely important from our exam point of view. With this, let's move on to the next news. The next news appears on page number 14. The news reads, SEBI orders forensic audit of Parasnath developers. Suspects misuse of books by realtor. In this particular news, it becomes important to know about this particular term, that is forensic audit. So in this news, let us understand this concept of forensic audit. So in this particular news, SEBI, that is Securities Exchange Board of India, has ordered stock exchanges to appoint an independent forensic auditor to audit the accounts of Parasnath developers, which is a Delhi-based real estate company. So in this respect, let us understand this concept of forensic audit. A forensic audit refers to the application of accounting methods for detecting and gathering evidence of frauds, embezzlement, or any other white-collar crime. And evidence gathered during such forensic auditing can be used in a court of law for the purpose of evidence to establish cases of fraud, embezzlement, or any other fraud relating to white-collar crime. And in this respect, it is important to remember that this forensic audit has nothing to do with forensic science. Further, it is also important to understand the difference between financial audit and forensic audit, as these are some of the terms which generally appear in the newspaper with respect to recent cases of frauds which are taking place either in banks or in some of the other institutions. So, difference between financial audit and forensic audit lies actually in the terms of objective as well as procedure. Financial audit is mere examination of financial statements of any institution or organization. Whereas in cases of forensic audit, it examines company's system of internal controls in order to identify any weakness in the system. And this forensic auditing may lead to uncovering cases of corruption, bribery, any cases of embezzlement, or any other cases in which wrongdoings have been committed. Now, this case of forensic audit can be also understood through an example. Suppose if a company X has entered into a contract with company Y for the supply of raw materials as recommended by its chief operations manager. However, when the company Y entered into a contract with company X, at that point of time, company Y was debarred from governmental authorities to enter into any contract. And this basic fact was not known to company X. Despite this ban on company Y, its chief operations manager still persuaded to go ahead with the contract. Such cases of corporate fraud cannot be exposed by mere financial audit. And it is here, in such cases, that the use of forensic audit can be benefited from. And in this respect, both Enforcement Directorate, that is ED, as well as Serious Fraud Investigation Office, that is SFIO, have underscored the need for a forensic audit, especially following the rise in case of money laundering and further cases of willful default, as such cases of willful default impact the entire banking system. In this respect, it becomes important to know both about Directorate of Enforcement as well as Serious Fraud Investigation Office, as questions can be asked both in prelims as well as in mains with respect to these institutions and their importance in uncovering frauds or cases of embezzlement in public as well as private institutions. So, this Directorate of Enforcement is a multidisciplinary organization mandated to enforce provisions of two specific laws, namely Foreign Exchange Management Act 1999 as well as Prevention of Money Laundering Act 2002. Further, this SFIO, that is Serious Fraud Investigation Office, has been recently accorded statutory status by the Ministry of Corporate Affairs, and this is done to tackle the diversified as well as sophisticated nature of corporate frauds under the Companies Act 2013. So, in this particular part, we saw about the role of Directorate of Enforcement as well as Serious Fraud Investigation Office, that is SFIO, which has been recently given statutory status by Ministry of Corporate Affairs to tackle corporate frauds specifically under the Companies Act 2013, and the Directorate of Enforcement, that is ED, is mandated to enforce provision of two specific laws, namely Foreign Exchange Management Act 1999 as well as Prevention of Money Laundering Act 2002. So all these institutions as well as acts will further help the case of forensic audit. As far as the syllabus is concerned, this topic forms a part of GS paper 2, specifically under statutory, regulatory and various quasi-judicial bodies, as we saw the role of SEBI, SFIO and ED, specifically with cases related to forensic auditing, and also under GS paper 3 under challenges to internal security through money laundering and its prevention. So in this aspect, it becomes important to understand the basics about forensic auditing. As mentioned, question may be asked with respect to how forensic auditing can further help in curbing such cases of money laundering, and how institutions as mentioned such as Enforcement Directorate as well as SFIO can further help in the cases of forensic auditing. With this, let's move on to the next news. The next news appears on page number 1 and also as a continuation on page number 10. This news is about alarm over deadly pest in Karnataka, and this news is with respect to an invasive species, that is fall armyworm, also termed as Spodoptera frugipeda, and this has been recently discovered in Karnataka by the Indian Council for Agricultural Research. And after discovering this particular invasive pest, ICAR has sounded the alarm bell with respect to this invasive species. As you can read that this particular invasive species, that is fall armyworm, is native to the Americas. This arrived in Africa in 2016 and since then it has spread to 44 African countries. So its tendency to grow and spread is very quick. It further says that it prefers maize but can feed on 80 species of plants including rice, sorghum, millet, sugarcane and cotton. Now in this regard, the ICAR has sounded the alarm bell because of its affinity to certain plants which are very important from the agricultural point of view, such as rice, sugarcane, as well as cotton. Before understanding the impact of this invasive species fall armyworm in Karnataka, let us first understand about invasive species. So the question is, which species can be termed as invasive? Such species which grow and reproduce quickly as well as which spread aggressively. And this potential to grow and reproduce quickly as well as to spread aggressively with the potential to cause harm are termed as invasive species. In this respect, an invasive species can be of any kind of living organism. For example, an amphibian like a cane toad, plants, insects, fish, fungus, bacteria, or even an organism's egg and plant's seeds. All these can be termed as invasive species. Another important aspect of this invasive species are that they are not native to the ecosystem and has the potential to cause harm by aggressively spreading in an entire region. And these invasive species have potential to cause harm particularly with respect to environment, health as well as economy. And these invasive species also impact the natural ecosystem including agriculture. In this respect, let us find about certain basic facts about the pest discovered in Karnataka, that is fall armyworm. Now this is a major maize pest, that is it feeds on the maize crop, and this pest is a native of North America which then arrived in Africa in 2016. And the finding of the pest in Karnataka is the first report of the pest in the entire Asia region. As per ICAR, this discovery is more worrisome because the pest feeds on around 100 different crops such as vegetables, rice, sugarcane, as well as cotton. The experience of its spread in Africa shows us how quickly this pest can spread in an entire region. It was first reported in Central and Western Africa in 2016, and so far it has spread to 44 African countries today. And the aggressive spread of this particular pest has not been easily controlled in Africa. So with respect to the aggressive spread of this particular pest as witnessed in Africa, it can be said that the states of Andhra Pradesh as well as Tamil Nadu are most vulnerable with respect to spread of this particular pest, that is fall armyworm. And the aggressive spread of this particular pest, that is fall armyworm, can have its impact on Indian agriculture as well as economy of such farmers who rely on their agriculture. So it becomes very important for the ICAR to find out ways or mechanisms to curb or control the invasive spread of this particular pest. So in this respect, let us also find out certain defense against this particular pest. Use of insecticides are always useful with respect to controlling such pest, and in this case insecticides like lambda cyhalothrin. Further, it says that some natural predators such as coccinellid beetles that can aid biological control. Further, a fungal species called Naweed riley also infects the fall armyworm. So all these defense mechanisms can be applied with respect to controlling the aggressive spread of this particular pest, that is fall armyworm. However, the news further says that these natural enemies may not be as effective as insecticides. So it says that the use of insecticides may be the most helpful way to control the spread of this particular pest. In 2018 prelims, a question on such invasive species was also asked by UPSC. Let's go through this particular question. It says, why is a plant called Prosopis juliflora often mentioned in the news? Now this plant Prosopis juliflora is a shrub or a small tree native to Mexico, and it is a very aggressive invader, especially in frost-free arid and semi-arid natural grassland. So in this respect, the options given by UPSC were: its extract is widely used in cosmetics, it tends to reduce the biodiversity in the area in which it grows, its extract is used in the synthesis of pesticides, none of the above. In this, the right answer was B, that is, it tends to reduce the biodiversity in the area in which it grows. So such questions of invasive species has been asked by UPSC very recently. So this news on fall armyworm, that is a pest which has been recently discovered in Karnataka, becomes very important. As far as your syllabus is concerned, in your prelims it forms a part of paper 1 specifically under environment, ecology, biodiversity and climate change. With this, let's move on to the next news. The next news appears on page number 12. The news reads Gokhale in US ahead of 2+2 talks. So in this particular news, let's learn about this 2+2 talks between India and the United States of America. It says Foreign Secretary will meet officials from White House and Departments of State and Defense. So in this particular news, India's Foreign Secretary has arrived in the United States for talks with senior US officials ahead of the 2+2 dialogue. And this 2+2 dialogue between India and United States is scheduled to be held in New Delhi in September 2018, in which America's Secretary of State Mike Pompeo and Defense Secretary James Mattis are scheduled to meet India's Minister of External Affairs, that is Sushma Swaraj, and India's Defense Minister, Nirmala Sitharaman. This 2+2 ministerial dialogue was established between India and United States, which would involve a dialogue between India's Foreign Minister and Defense Minister, US Secretary of State and US Defense Secretary. Hence, 2 officials from India and 2 officials from the United States of America. Hence, this ministerial dialogue is also known as 2+2 dialogue. In this regard, India has similar 2+2 dialogue meetings with Australia as well as Japan. And this 2+2 dialogue with Australia and Japan is held among the Foreign Secretary and Defense Secretary of the 2 nations. So in this respect, it's important to note that the 2+2 dialogue with United States is between India's Foreign Minister and Defense Minister with that of US Secretary of State and Defense Secretary, whereas 2+2 dialogue with Australia as well as Japan is between Foreign and Defense Secretaries between the 2 nations. So in this backdrop, let us understand what this upcoming 2+2 dialogue between India and United States aim to focus on. So this particular dialogue primarily aims to focus upon US Foundational Defense Agreements, that is Communications Compatibility and Security Agreement, or also known as COMCASA, and Basic Exchange and Cooperation Agreement, that is BECA. It also wants to discuss on issues such as future implication of US CATSA law, that is Countering America's Adversaries Through Sanctions Act, recent tariff issues between US and India, and the most contentious issue of US sanctions on Iran and its impact on India. In the upcoming 2+2 dialogue, India and the US may also deliberate upon various defense collaboration. So in this respect, let us go through some of the defense agreements between India and the United States. It says that the US has 4 foundational defense agreements that aid United States in defense engagement with the other countries. And in this, India and United States have already signed the first 2 US defense foundational agreements, that is this one and this one. Basically, General Security of Military Information Agreement and LEMOA, or Logistics Exchange Memorandum of Agreement. So these 2 agreements have already been signed between India and US. And in the upcoming 2+2 dialogue, it is these 2 defense agreements which would be deliberated upon. That is Communications Compatibility and Security Agreement as well as Basic Exchange and Cooperation Agreement. This 2+2 dialogue between India and US is yet to take place in September 2018. So let's wait and watch what are the issues which are discussed in that particular meeting and what is the outcome of that particular dialogue. As far as the syllabus is concerned, this forms a part of GS paper 2, specifically under bilateral, regional and global groupings and agreements involving India or affecting India's interest. So this is an ongoing news. Let's wait and watch for the final outcome. With this, let's move on to the next news. The next news appears on page number 9. The news reads, Reforming the Civil Service. The lateral entry scheme has potential to bring fresh talent to bureaucracy. Now in this particular news, various issues have been raised with respect to threatening of the hegemony of existing IAS lobby, end of neutrality and impartiality with the bringing of lateral entry scheme in the civil services. And another important issue which has been raised is with respect to the concept of privatization of IAS. Effectively, where it has been said that the business lobby may plant their respective officers at various plum posts. for their own benefits. So all these issues becomes important with respect to the current aspect of lateral entry which has been allowed at the post of Joint Secretary in the Government of India. As you can see, a question has already been asked in the year 2017 mains. The question read, initially civil services in India were designed to achieve the goals of neutrality and effectiveness, which seems to be lacking in the present context. Do you agree with the view that drastic reforms are required in the civil services? Comment. Now, this entire news with respect to reform in civil services, that too with respect to lateral entry, becomes very crucial in the present context. Now, with respect to decision making, it's important to understand that Secretariat plays crucial role in the final consultative process of decision making, and such process at times are quite complex as well as cumbersome. Moving files through such labyrinth in the Secretariat requires experience as well as expertise, and the entire process goes through a number of approval at various levels. In such consultations, senior officials from the rank of Joint Secretary to the rank of Secretary helps the political executive, that is the minister, in taking the final decision. Thus, the Joint Secretary performs this crucial line function of policy formulation as well as its implementation. Original programs and schemes are, however, prepared by the specialist, but its final approval is provided by these generalist IAS officers, starting from the rank of Joint Secretary to Additional Secretary, Secretary, and finally by the Minister. So, in such a complex decision making process, it is generally asked whether the higher bureaucracy is equipped to handle such complex process, where you need technical as well as economic specialization to handle such complex issues. Another issue is whether such bureaucrats can provide competent guidance to the minister specifically with respect to the subject specialization cases. So, considering all these aspects, the concept of lateral entry assumes significance in this backdrop, as it brings with itself fresh set of ideas as well as expertise in subject domain. And to overcome the issue of neutrality as well as impartiality in civil services, UPSC can be given the task to handle the recruitment process with respect to lateral entry, in which outstanding candidates must be inducted permanently through a fair process, and this also must be taken care by the UPSC, that is Union Public Service Commission. So in this aspect, let us also go through the impact of lateral entry on our bureaucratic process. It says that it will help in bringing expertise from the private sector in diverse field who is not accustomed to the practices and procedural labyrinth of bureaucracy. It further says such persons can help in infusing new thought process which will further help in imbibing best practices of both worlds, that is public as well as private. And this will also provide a fresh set of ideas as well as approach to the governance system. This induction of fresh idea will further encourage the bureaucrats to gain experience in specific fields in their early stages of careers. Specialization in diverse field will further help serving bureaucrats in having a longer tenure as an officer in respective field of expertise. So all these aspects must be considered with respect to impact of lateral entry in the bureaucracy. So this article on reforming the civil services becomes extremely important, as we saw that a question has already been asked with respect to neutrality as well as effectiveness of the entire civil service system in the country. With this, we come to an end to discussion of today's newspaper. Please subscribe to our channel and press the bell icon for daily DNS updates. With this, let's move on to the question for the day.